Okay, so we're going to look at the Law Commission. So the Law Commission get their powers from the Law Commission Act 1965 and then the Law Commission Act 2009. So it was set up in 1965. So what did they do? Well, they consider areas of law that they need or that they believe need to be reformed, and they will sometimes get those areas of law from the government. The government will ask them to look at something, or they will decide to look at an area of law. What they do is they consult relevant parties and they produce a report. And they are actually really interesting because they look at the problems in the law and then they actually make really good suggestions. In their report, they often produce a draft bill and then they present their report to Parliament. So certain things that they want to do, they want to repeal some laws. So that just means they want to remove laws, particularly out-of-date laws. There are a lot of outdated laws, over 200. I mean, there must be more. The other thing they want to do is consolidation. So often you find acts of Parliament, like, for example, bail. Let's use bail as an example. The Bail Act 1976. Well, there was a Bail Amendment Act 1993. In more recent acts, they have mentioned changes to bail. So consolidation, instead of having 5 different acts that mention bail, it's like, let's just have one act, put them in one act. So much easier. And then codification. Sometimes in law, offences against a person, you have an act, and then you have cases. You have Chan Fook that says mental harm is bodily harm. You have DICA that says HIV is biological GBH. So you've got an act and you've got cases. Codification is putting them all into one act. Again, much more straightforward. So the Lord Chancellor may ask the Law Commission to look at certain areas of law, and they do their research, they do the consultation, which is a paper, and then the proposals for reform will be presented to Parliament. So examples of acts that have come from Law Commission reports: Corporate Manslaughter Act 2007 made it much easier to prosecute the managing directors or shareholders of a company if somebody dies. The Coroners and Justice Act 2009 changed the special defences to murder. They changed provocation to loss of control and made it a stricter defence. And then the Consumer Rights Act 2015, this actually consolidated several other acts. So the law on consumer rights was all over the place. There were lots of acts, lots of directives and regulations, and the Consumer Rights Act put them all into one place. Okay, so what is good about the Law Commission? Well, advantages of the Law Commission: areas of law are being researched by legal experts. They're independent. They don't have a political motive. They're good. They have knowledge in the law. When they're writing the reports, they are going to be detailed. They're going to contain few errors. And the next kind of issue is that, well, whole areas of law can be considered, not just small issues. So really detailed reports is very helpful for Parliament because it saves them time. They don't have to research the area of law. They can read the reports, they can look at the bill, and then it can go through the normal legislative process. The other advantage is they consult a lot of people, a lot of bodies, and will suggest ways to improve the law. They want to make it fairer, they want to make it clearer, they want justice to be achieved. And it can lead to the modernisation of laws, like the repealing of old laws, the introduction of new laws. It makes the law clearer for the public. The Consumer Rights Act, a much clearer act of Parliament. It makes it more accessible, and that then follows the rule of law, that law is accessible and understandable to all. However, there are some disadvantages. Parliament doesn't have time to read all of these reports and consider them all. So it may not be their priority to change the law. I mean, in 2015, the Law Commission produced a massive report, really detailed, on non-fatal offences, and Parliament has not changed the law. It's just simply not their priority to do so. They also don't want to change laws if they're going to be unpopular with voters. So that kind of leads into another disadvantage, that often reports are not acted upon, like the 2015 non-fatal offences report. So what happens is you've wasted time, you've wasted money, you've wasted resources, and this old 1861 Act continues to exist with many problems and many injustices, and Parliament just simply aren't going to change the law. The next thing to think about is that even if the government does accept the report and thinks, right, okay, we want to make this law, it still has to go through the really lengthy process of becoming law. So, from the stage of bill, first reading, second reading, committee stage, report stage, third reading, repeat in the House of Lords. So this report may still not actually become law, and it may become law years later. And sometimes even then it's already out of date, particularly if it's to do with some kind of online issue or the internet or social media, things like that. So it may never become law. Okay, so hopefully that has helped you a little bit with law reform and influences on Parliament.